You are welcome back for today's broadcast. Today is 13th February 2026. In fact, the whole thing is getting hotter every day in Nigeria, and concerning the issue of Tinubu and the US issue, and how the Donald Trump is giving him fire in his body every day. So, according to the news reaching to us, title, they said Tinubu under pressure plans urgent visit to UK to stop Trump, US Congress not to divide Nigeria. As you can see, although the US Congressman Chris Smith and Rory Moore, they have said things concerning this issue of Nigeria being divided, and how they are talking about division of Nigeria. Although they are saying that they are not talking about it, but you can recall the last or day before yesterday video we post where the Baba Ghana was saying that Nigeria is not the people that will determine their fate. The fate is not in Nigerian hands to determine what will happen in the future. So as it is, they are afraid of what may happen or what may not happen, and their mind is not at rest. Although they may be saying that they don't want to divide the nation, but still yet they are into panicking because they don't know what is happening. So in this video, don't skip any part of it, because this our brother activist is going to explain to us a lot concerning what is really happening in Nigerian politics and the visit of Tinubu, what we are expecting to see, and the reason why he's going to that visit, because a lot is happening. A lot is happening concerning the issue of U.S. judge court now asking for his criminal record. How the Donald Trump is fighting against the Christian genocide in Nigeria, and how the terrorists, as they are doing meeting upon meeting, how they are going to close this issue of the atrocity that's going on in Nigeria. And the lobbies, the money, type of money is paying outside of the country for them to just close everything that is going on in Nigeria. In fact, a lot is happening. A lot is happening in Nigeria. So don't skip any parts. As you're about to watch, like, subscribe, and share the video to go around. Let others see things going on in Nigeria.
All right, everywhere is now hot in Nigeria, and also for the president in particular. I doubt if the president can sleep well in the night now. Well, he's not finding it easy. Explanation full in body now. He's planning to visit UK, to go and meet UK and tell them how far what is happening. When I leave only me, I can't suffer am alone. That is the plan now. He's planning to go to UK.
This February, just yesterday, ordering the FBI and the DEA to release additional related records. Why? Ask yourself. Why is this moving now at this particular moment in geopolitics? Timing matters in politics. Let us line up the timeline. I'm going to carefully line up the timeline. Please bring out your pen and paper and start writing. Sokoto is bombed. The caliphate is bombed by Tomahawk missiles sent by Trump. Sokoto Caliphate. The First Lady, Remi Tinubu, shows up in Washington, D.C. The next thing, U.S. troops land in Nigeria. And then people are taking pictures everywhere, photo up. Plenty picture taken with Tinubu, usually surrounded by Americans. And now, yesterday, U.S. courts move. And suddenly, a state visit to the United Kingdom is arranged. Let us pause here and talk about standards. Suddenly, Tinubu wants to go and meet the king in UK. In Britain, the royal family, as we speak, has faced and is continuing to face intense public scrutiny over Prince Andrew's ties to Jeffrey Epstein. King Charles has had to navigate calls for transparency and accountability, even within his own family. Prince Andrew is his brother.
So, on the other hand, is about Nnamdi Kanu's case. He filed an appeal. He took his time to file an appeal. And I want to believe that this time around that he's going to be set free with the coming of the US into Nigeria. I bet you that so many things are going to be resolved. and hopefully he's going to regain his freedom.
I have asked you here, what is that thing that the Igbo man have done in Nigeria? What crime did they commit? Mr. Okoro, look at how peaceful these people are, going about their business, contributing and adding value to the economy of Nigeria. Yet, it is not good enough. But look at terrorists. Very, very annoying. Terrorists that are adding nothing to the Nigerian economy.
Do you know what it means to bring up a case, to bring up the decision of a case where plea bargain was conducted about, they said about $450,000 US. You know, a big case. You know what it means to bring it up as a president? Nigeria money fit finish there. You know, consign them. So, but this time around, I don't think money can solve the problem now, because had it been the president entered and do as much as possible to better people's life, you know, it wouldn't have gone to this level. Let me give you an instance. When Chris Ngige entered and Peter Obi challenged the election that brought Chris Ngige, what he did, he tried as much as possible to work. In fact, he is the one that made people know that there is money in Anambra State, because he was working with good construction company, or not all these companies. That's what Chris Ngige did. And Anambra was far, far better than what it used to be. So people loved him, even though he was not the rightful winner of that election. You see the point. But in this case, nothing. There is no place you can hold, not economy that you can hold. People are going hungry, and in the same case, in the same situation, money, they are planning to take money through tax from people. How bad? What thing we do now? Well, listening to this, no, I usually don't want everything to come from me. Just listen to this video. We'll come back, we'll continue.
Fresh U.S. court wahala for Tinubu. About 24 hours ago, I told you, U.S. troops are now on Nigerian soil. Yesterday, something else moved. A United States federal court has ordered the FBI and Drug Enforcement Administration, DEA, to release records related to President Bola Ahmed Tinubu of Nigeria. Let us be precise. The case in question is titled, let me give you the title of the case, United States versus Bola Ahmed Tinubu for Future Proceedings, Northern District of Illinois, 1993. That was the case. That is not a rumor. That is a federal case. Yesterday, a federal court weighed in. Now, because some of you are asking, what exactly was this about? I'll quote directly, so that is not my words, from Daily Trust, one of Nigeria's most established newspapers, Daily Trust. According to Daily Trust, yesterday, Monday, quote, Tinubu was said to have forfeited $460,000 to the American government in 1993 after authorities linked the funds to proceedings of narcotics trafficking. Narcotics trafficking! And further, quote, at the Presidential Election Petition Court, the issue of Tinubu's forfeiture of the funds featured prominently when his opponents Atiku Abubakar and Peter Obi challenged the president's eligibility to contest Nigeria's presidency, unquote, unquote. None of this is my words. Those are direct quotations. Now, let us be clear, because I like to be thorough and to be accurate. This was a civil forfeiture proceedings in the United States. Clearly, it had nothing to do with Nigeria. In terms of this thing did not happen in Nigeria, it happened in the US. President Tinubu has denied wrongdoing. Those are the facts. But here is where it becomes geopolitical, not historical. Why is a U.S. federal judge in 2026, this February, just yesterday, ordering the FBI and the DEA to release additional related records? Why? Ask yourself. Why is this moving now at this particular moment in geopolitics? Timing matters in politics. Let us line up the timeline. I'm going to carefully line up the timeline. Please bring out your pen and paper and start writing. Sokoto is bombed. The caliphate is bombed by Tomahawk missiles sent by Trump. Sokoto Caliphate. The First Lady, Remi Tinubu, shows up in Washington, D.C. The next thing, U.S. troops land in Nigeria. And then people are taking pictures everywhere, photo op. Plenty picture taken with Tinubu, usually surrounded by Americans. And now, yesterday, U.S. courts move. And suddenly, a state visit to the United Kingdom is arranged. Let us pause here and talk about standards. Suddenly, Tinubu wants to go and meet the king in UK. In Britain, the royal family, as we speak, has faced and is continuing to face intense public scrutiny over Prince Andrew's ties to Jeffrey Epstein. King Charles has had to navigate calls for transparency and accountability, even within his own family. Prince Andrew is his brother. That is how institutions protect credibility. So the king is scrambling here. He's telling police, come and investigate my brother, I have nothing to do with this. They submit to scrutiny. Then pivot to Nigeria. Pivot to that Nigerian president who is going to visit King Andrew now. So as His Majesty prefers, as he prepares to meet Nigeria's President Bola Tinubu, Nigerians then are wondering, they're entitled to ask a simple question. This is somebody willing to tell his brother to face justice? Does accountability apply universally? Does it? If Western institutions can withstand investigation of their own elites, this is the king's brother. We decide to remove from him. Should African leaders be treated differently? If there are court records in the United States still being contested, court records involving Bola Tinubu and released in 2026, does that raise legitimate questions about transparency? Ladies and gentlemen, diplomacy cannot be a shield against scrutiny. Just meeting somebody, greet, how are you, Your Excellency? That's not a shield against scrutiny. Nigerians are not asking the King of England, King Charles, to prosecute anybody. Nigerians are asking for equal standards for everybody. If accountability is a principle in London, it should not disappear when African leaders like Tinubu arrive to come and take picture to show that they are close to the king and close to the UK. That should not happen. If I were the king, myself, that's me, I'll put Tinubu aside and say to him, what is in this court document involving you and this federal judge in the US that the man was released? So for purposes of transparency, tell me, please. That's me, that's what I would do. I'm not telling you what I would do. That is what I would do if I were the king. Ladies and gentlemen, sovereignty does not mean immunity from scrutiny. It means strength under scrutiny. That's what it means. And on the other hand, where is the direct engagement with the President of the United States? President Donald Trump. Why is Tinubu not meeting President Trump? People have wondered. He seems to be meeting with everybody. If the relationship between Nigeria and the UK is strong, well, that's what some of Tinubu say, no problem. Everything we are doing together, we are cooperating. If they are strong, as some of Tinubu's supporters claim, why not bilateral summit at the highest level? This is the most crisis I've seen between Nigeria and the US. Why not have a summit? Why no Trump-Tinubu meeting? Why intermediaries? Why send middlemen? Why choreography? In international politics, access is power. Absence of access is also a signal. This is not about 1993, ladies and gentlemen. This is about leverage in 2026. Simple. When a sitting president has a long-standing and politically contentious legal history in U.S. court records, that continues to generate political and judicial scrutiny. even if civil, even if long ago, it creates reputational vulnerability for the president. And reputational vulnerability affects negotiating strength. I'm saying this so the President Bola Tinubu will understand. That is not an accusation. It is diplomatic reality. Since he runs Nigeria, Nigerians are entitled to ask him questions. He's not a king. In Abuja, is Abuja negotiating from strength, really? Especially on issues like U.S. troop presence, counter-terror operations, all this. Are they really operating from strength? Or are they being forced to do this? Are they operating from constraints? Things that are holding the president. If there's nothing further of concern in these records in U.S. courts about anybody, a full release should settle the matter. Let it be fully released. But do not pretend that simultaneous military movement, court pressure, and urgent diplomatic choreography are unrelated. All these things are related to each other. Too many things are moving at once. Too many moving parts. And Nigerians deserve clarity. This is not personal. This is institutional. A sovereign nation like Nigeria must not operate under whispered leverage. Whisper, whisper, whisper. This is my message for Asiwaju, the president of Nigeria. If you as Nigerian president cannot sit one-on-one, or if you as Nigerian president can sit one-on-one rather with global leaders like the King of England in London, then you should be able to sit one-on-one with the President of the United States. Why not? That's the one that actually bombed your own country. If the president cannot, Nigerians deserve to know why. Let him tell us why. Not slogans, not surrogates, not grammar, not State House press release by Bayo Onanuga. If Trump has refused to meet with him, tell us that the man doesn't want to meet with me. Nigerians can take it. Subscribe, comment, push notifications. This is the Ofion Okwa Show. We don't just report events. We track where they lead. I am and remain the voice of the voiceless. Your independent voice. That's what I'm doing today. Telling fearless truths. I do this every day. And sometimes laughing at the failing and inept Nigerian power while doing this. I they laugh them sometimes. I am Ofion Akwa. Take care of.
Also, we are not neglecting the fact that you can see that Nnamdi Kanu has been vindicated. Everything he said is what is happening now in Nigeria. Is that not enough to allow this man? In fact, if it had been in a serious company, in a serious country, they would have called this man Nnamdi Kanu, probably keep him in a place that they will be working with him. In fact, government is supposed to have adopted him as their own personal son and be working with him. But in this country, you know, we kill intellectuals. It's very easy to kill intellectuals. We don't care about them. That is the problem with this country. Well, that court will say, okay, release him. Appeal court of appeal say release him and the Kanu. Another court will say hold him. What kind of system are we running in Nigeria? Well, having said that, I want you to listen to this update. If you want to get the current update of Nnamdi Kanu situation, you know Nnamdi Kanu still have right to appeal. So he has 90 days to do that, but he never rushed into that. He took his time to give that appeal. So listen to this update. You will get more in-depth information about Nnamdi Kanu's case. Let's listen.
Nnamdi Kanu has gone on appeal against the judgment of the Federal High Court that convicted him last year. Remember that Honorable Justice James Omotosho, in the judgment of the Federal High Court, made pronouncement against Nnamdi Kanu and sentenced him to terms of imprisonment. A few days ago, Mazi Nnamdi Kanu has filed a notice of appeal against that judgment. Remember, in law, Nnamdi had 90 days to file an appeal against the judgment. Some people thought that he was going to file the appeal almost immediately after the pronouncement was made against him. But I think it took his time. and then decided to just make sure that he files it within the 90 days. So he's still within the 90 days at the time of the filing of this notice of appeal. So in this video, we look at the grounds of appeal in summary. There are quite many, but we look at them in summary. We look at the position of the law, and we then look at what to expect. Nnamdi Kanu is the person that has filed the appeal by himself. And that is why you say, take notice that I, Nnamdi Kanu, lawyers will see that this is not the regular language of the notice of appeal, okay? But he's saying, I, Nnamdi Kanu, so it's allowed. He is the person that has filed the notice of appeal against the judgments that was delivered against him. And he was sentenced, he said that he was sentenced for 7 numbers of offenses. I hereby appeal as follows. Ground number 1, he's saying that the judge was wrong in law for failing to resolve what Nnamdi calls procedural and competence consequences of the foundational disruption of the original trial processes in September 2017. You remember that Operation Python dance that something happened in his father's compound in Afaruku in Abia State, and that led to Nnamdi running for his life. So Nnamdi is saying that when he came back for trial, the judge ought to have first of all resolved that very issue before proceeding. That's ground number 1. Ground number 2, he's saying that the judge was in error by failing or refusing or neglecting to hear and determine his pending preliminary objection challenging the competence of the proceedings. Remember that Nnamdi had filed an objection challenging the competence of the proceedings at the Federal High Court. So he's saying that the judge was wrong in failing to have determined that. Ground number 3, he is saying that the judge was in error by proceeding to judgment and convicting him while his application for bail was yet to be determined. That's what Nnamdi is saying. That's ground number 3. That the judge should have determined his bail application before proceeding to hear and determine the entire matter. Well, lawyers in the Ministry of Justice will have a response to that. They may likely say that bail is at the discretion of the judge and so on, but it's left for them, right? Number 4, he's saying that the judge misdirected himself when he treated his absence from 2017 to 2021 as a basis for adverse inference without proper consideration of evidence that compelled his absence. Still remember that invasion of his father's house in Afaruku. Ground number 5, Nnamdi is saying that the judge was in error in trying and convicting him upon proceedings previously declared nullity ab initio by the Court of Appeal. Remember that the Court of Appeal had said that the trial of Nnamdi Kanu was a nullity. The Court of Appeal had said that. But I see the Ministry of Justice also replying that the matter had gone up to the Supreme Court, and the Supreme Court did not say it's exactly the same thing. Supreme Court ordered for retrial. But that's one of the grounds that Nnamdi has raised. Ground number 6, Nnamdi is saying that the judge was in error by treating an interim stay of execution order as capable of lawfully suspending the operative effect of the Court of Appeal's final criminal judgment. So you remember that the Court of Appeal had said release him. Federal government said they filed notice of appeal they filed stay of execution. And Nnamdi is saying that the judge was wrong to have given recognition to that stay of execution instead of discharging him. 7, that the judge was in error in subjecting him to a renewed jeopardy in respect of substantially overlapping facts. So he's saying that the judge was in error to have tried him after he had already been tried in the same matter, the same facts, and so on, and the Court of Appeal had even made a pronouncement in his favor. Ground number 8, he's saying that the trial judge was in error and that he misapplied the judgments of the Supreme Court, which talked about taking the matter back to the trial court. Ground number 8, Nnamdi is saying that the trial judge was in error of law by convicting and sentencing him under the Terrorism Prevention Amendment Act 2013, which Nnamdi says was repealed in 2022. Okay? Ground number 10, Nnamdi is saying that the judge was wrong in law in assuming jurisdiction over extraterritorial allegations. Remember that most of the allegations was that he made a broadcast from the United Kingdom, which was heard in Nigeria. Nnamdi is saying that the judge was wrong to have assumed jurisdiction over something that did not happen in Nigeria. Number 11, Nnamdi is saying that the judge was wrong in law to have denied him fair hearing by proceeding to judgment without permitting him to file and present a final written address. Remember that that's one of the complaints that Nnamdi raised at the trial court. He said he has not been given an opportunity to file final written address. That's one of the grounds now that he has taken to the Court of Appeal. Number 12, he said that the judge was wrong in law by convicting him on count 1 without proof beyond reasonable doubt of any preparatory act constituting the actus reus, that's the act itself of the offense. Ground number 13, Nnamdi is saying that the trial judge was in error in convicting him on count 2 based on alleged broadcast without proper authentication, proof of transmission of the broadcast, authorship of the broadcast by him, intimidating effect on the populace. That's one of the grounds, okay? Ground number 14, Nnamdi is saying that the judge was wrong in law to have convicted him of ground number 3 without cogent admissible evidence of membership or leadership of IPOB. Nnamdi is saying there was no evidence that he's a member of IPOB or that he's the leader of IPOB. There was no cogent and verifiable evidence before the court, and the court went ahead to convict him, okay? Number 15, Nnamdi is saying that the judge was in error of law by convicting him on counts 4 and 5 without proof of communication of the alleged incitements. Remember that one of the allegations was that Nnamdi, through his radio broadcast, has been inciting people to take up arms in the East against the government of Nigeria, against policemen and so on. Nnamdi is saying that there was no evidence of communication of that. There was no proof of communication of that against him. Ground number 16, Nnamdi is saying that the learned trial judge was wrong in convicting him of count 6 without proof that any bomb or explosive device was manufactured or that any person acted on the alleged direction by him. 17, he is saying that the judge was wrong by convicting him on count 7 without proper proof of possession or importation, okay, of transmitters. 18, he is saying that the judge was wrong to have overruled his no-case submission. Remember that the judge had overruled Nnamdi's no-case submission and asked him to enter his defense. Nnamdi is saying that the judge was wrong to have overruled that no-case submission, that there was every reason for the judge to have let him go. Number 19, he is saying that the trial court was in error of law by convicting him without proof by admissible evidence that the alleged crimes occurred or of the essential prohibited consequences required by the count failure of corpus delicti, okay? 20, he is saying that the decision of the learned trial judge is unreasonable, unwarranted, and cannot be supported by law having regard to the weight of admissible evidence. 21, he is saying that the judge failed to apply the African Charter on Human and People's Rights, which is a binding legislation to afford him fair trial and liberty. And 22, Nnamdi says that the judge was wrong in law in imposing sentence without taking his allocutus. You know that allocutus that is usually given to an accused person who has been convicted. Before sentencing, the accused person is usually given an opportunity to say something, possibly plead for leniency. Nnamdi is saying that he was not in the courtroom. He was not allowed to stay in the courtroom and make his allocutus. And that by not allowing him to be in the courtroom and make allocutus before sentencing, that the judge was wrong in law. Okay? So those are the grounds of appeal that Nnamdi has raised. Nnamdi has raised a total of 22 grounds of appeal. It's actually a long notice of appeal. The particulars are there and so on, but because of time, we cannot bring in the particulars one after the other. Now, what are the reliefs that Nnamdi is seeking? Because in law, when you file a notice of appeal, you raise the grounds of appeal. The next thing you do is to tell the Court of Appeal what you want the Court of Appeal to do for you. That is called in law reliefs. So what are the reliefs sought? 1, an order of the Court of Appeal allowing the appeal. That is, agree with this appeal and set aside the judgment of the trial court. 2, an order of the Court of Appeal quashing the conviction. Remove all that conviction that was made against me. Okay? 3, an order of the Court of Appeal quashing, reversing, and setting aside the sentences and punishment imposed on Nnamdi Kanu. Okay? Number 4, an order of the Court of Appeal discharging and acquitting Nnamdi Kanu in respect of all the counts of the charge that was presented against him at the Federal High Court. Number 5, Nnamdi says, for such further orders as this Honorable Court may deem fit to make in my favor in the circumstances of this appeal. Now, let's look at the position of the law on this. Number 1, the notice of appeal is signed personally by Nnamdi Kanu. I said that from the beginning. By law, a person who has been convicted and sentenced to terms of imprisonment, he has the right to file his notice of appeal by himself or by a legal practitioner of his choice. In this case, Nnamdi has chosen to file the notice of appeal by himself. That is within the confines of the law permitted. Number 2, having filed the notice of appeal, Nnamdi has to go to the registry or to the registrar of the Federal High Court and pay the prescribed fees to the registrar. His appeal can be, to be paid to the registrar may be, because of the volume, can be up to 5 million, it can be up to 3 million, it can be up to 2 million, depending on the volume. And the registrar will be expected to transmit that in not less than 12 volumes or sometimes 15 volumes from the Federal High Court Abuja, where he was tried, to the Court of Appeal Abuja, where the matter has been appealed to. Okay? Transmission to the Court of Appeal. Number 3, next will be for Nnamdi to sit back and prepare his brief of arguments into sufficient copies. It will be sometimes as big as this. He will prepare his brief of argument, stating the facts, stating the law in support of his notice of appeal, and then telling the Court of Appeal to discharge him because of this law, because of this fact, and so on. Those, the brief of argument will now have to be served on the Attorney General of the Federation, who will respond or assign it to a private legal practitioner and give him the fiat to prosecute for the federal government. Remember that at the trial court, it was done by a Womolo, Senior Advocate of Nigeria, through the fiat of the Federal Attorney General, and then the Attorney General can decide to do the same thing in the appeal, and then the appeal will be heard. Now, Attorney General's reply will be served on Nnamdi Kanu, and when that is done, Nnamdi has the right to file what is called reply brief. When Nnamdi files reply brief, that means all the 3 briefs have entered, and the appeal is ripe for the Court of Appeal to fix a date, and then hear the parties, get it adopted, and then give judgment. When all the briefs are filed in, the Court of Appeal will hear the parties who will be expected to adopt their briefs of argument. The court will then adjourn to deliver its judgment on the appeal within 90 days. Once the appeal is adopted, judgment must, as a requirement of law, be decided within 90 days. Judges will tell you that they do not want to miss the 90 days mark because it's a constitutional requirement. If you miss it, NJC queries you. So that is why within 90 days of the adoption, judgment is going to be delivered, and Nnamdi will know, his fate in the matter. Nnamdi can represent himself at the Court of Appeal. He can go to the Court of Appeal and argue his appeal. It's allowed. If he feels he can do that, if he knows that he has what it takes to do it, the law allows him to do it, right? He can also do so through legal practitioners of his choice. He can also do it with a team of legal practitioners. He can appear in court like this and do it by himself, right? Now, the choice is that of Nnamdi Kanu, to choose whether to pursue this appeal by himself or to bring in lawyers at this point to assist him. If you ask me, I would tell Nnamdi Kanu to seek the services of lawyers that he can trust, those that he believes can do the appeal for him. Why am I saying so? I'm a practicing lawyer. I've done matters at the trial court, I've done matters at the appellate courts, And I can say it clearly that appeal is a technical matter. Appeal is a technical endeavor. It's like, in secondary school we did maths, and we also did further maths. Appeal is like further maths. You need to understand maths before you can do further maths, okay? So, my advice, Nnamdi should consider it necessary to bring in lawyers at this point to do the appeal for him at the trial court, even though the law allows you to do it by yourself. But sometimes I see it as a trap of the law. The law puts a trap for you. So, go and do it. Yeah, you want to do it by yourself, so you go and do it. But you will not be able to understand the nuances of law, let alone the nuances of appeal. I would suggest, like I said, that he should get services of lawyers to defend him, but it's still left for him. He can decide to do it by himself. Some people have done the appeal by themselves, and then if your appeal was good, you win. There's no doubt about that. Okay? Now, I'm wishing Nnamdi the best as the events of the appeal unfold. I wish him all the best in this. Nigerians would want to know how this goes. We expect that the appeal will be filed as quickly as possible, and then it will be heard as quickly as possible too. Many thanks always for watching.
Oh yes, my people, the matter no be here. Everywhere is boiling. The issue concerning Nnamdi Kanu court case appeal, we believe that is going to have victory over all the allegation and everything the Omotosho lay against him. We believe that is going to have victory over them all, and the case is very serious, very very, in fact, very serious. Then coming down to issue of Tinubu trying to go into UK to present himself and doing a lot of things. He's afraid of the thing that may happen into the country. He's afraid of US. He's afraid of the issue of Biafra and the issue of division of Nigeria. So you can imagine somebody who paid 900 million US dollar to lobby what is going on now, but mostly the Christian genocide and the issue of division of Nigeria. He paid 900 million for all those things to be closed. So to show you that, to tell you that he's not sleeping well at all. They may come out and present themselves in a way as if they are okay. They are not. So they are not. The thing that is happening in the country is giving them sleepless nights. Mostly this issue of Nigeria, no place is at rest. Everywhere is, in fact, every left and right, everywhere is crying. No place, nobody is happy in the country. And also is also chasing mostly how you will gain power during 2027 election. This is his main problem, how we gain power 2027 election, because the way the North and the South, all of them is fighting against him because of what he's doing that is not proper in the government. Well, and I would like to hear your comment down below. What do you think about the whole thing going on in Nigeria? Like, subscribe, and make sure you share the video to go and let others see what is happening. And I would like to hear your comments down below. Thank you for watching.